Dead ends. The last person to see him was never questioned. The last photograph ever taken of Danny Croteau shows him smiling. He is 14 years old. He is wearing a baseball cap slightly tilted to the left. Behind him, the Connecticut River moves slow and brown in the early spring light. 3 days later, his body was found in that same river. He had been beaten. He had been drowned. And the man who drove him to the riverbank that night, the last person to see Danny Croteau alive, was never brought in for formal questioning. Not that week, not that year, not for the next 30 years. Danny disappeared on the night of April 14, 1972, in Springfield, Massachusetts. He was a paperboy. He came from a working-class Catholic family with 7 children. He had no enemies. He had no criminal record. He had no reason to be afraid, and yet, someone knew exactly where to find him. Springfield police opened a case file. Witnesses were interviewed. A suspect emerged almost immediately. A man Danny knew personally. A man with access to children. A man whose name kept surfacing in the investigation. That man was never questioned. The file was never closed. And Danny Croteau never got justice. This is not a story about a monster hiding in the dark. This is a story about a system that looked the other way. About investigators who stopped asking questions when the questions got uncomfortable. About a family that spent 50 years demanding an answer that was always one interview away. You are watching Dead Ends, and this case is far from over. Springfield, Massachusetts, 1972. It is a city that still believes in itself, but just barely. The manufacturing jobs that built it are beginning to leave. The neighborhoods are shifting. The Catholic Church is the spine of the community, the parishes, the schools, the social fabric that holds working-class families together when everything else starts to fray. The Croteau family lives on Dynamite Street, a name that sounds harder than the people who live there. Carl Croteau works long hours. His wife, Bunny, raises 7 children in a house where there is never quite enough of anything, but where there is always enough love to make the difference invisible. Danny is the 5th of 7. He is not the loudest child in the house. He is not the one who demands attention. He is the one who shows up for his paper route for Sunday Mass, for his siblings when they need someone steady. His customers on the route know his name. They leave tips. They ask about his week. He is by every account a good kid in the uncomplicated way that phrase actually means something. He also knows Father Richard Levine. Levine is the associate pastor at St. Catherine of Siena Church in Springfield. He is young for a priest, 30 years old in 1972. He drives a nice car. He takes boys fishing. He organizes camping trips. He is, in the language of that era and that community, beloved. He is the kind of priest parents trust instinctively. He is the kind of priest who makes himself indispensable to families who are stretched thin, who offers rides, who shows up, who pays attention to the boys that no one else has time for. Danny Croteau is one of those boys. The relationship between Danny and Father Levine is not a secret. The family knows Levine. Levine visits the house. He takes Danny on outings. In the world of Springfield's Catholic working class in 1972, this is not alarming. It is normal. But there are things the Croteau family does not know. They do not know that other boys have already begun to pull away from Levine, quietly, without explanation, the way boys do when something has happened that they have no language for. They do not know that within the Diocese of Springfield, there are already whispers. Not formal complaints, not documented reports, just the kind of institutional unease that organizations bury before it becomes a problem. They do not know any of this, because no one tells them. April 14, 1972, is a Saturday. Danny finishes his paper route in the morning. He spends part of the afternoon at home. Sometime that evening he leaves. His family will later recall that he seemed normal, not agitated, not afraid. He was going to meet someone he knew. The Connecticut River is approximately 2 miles from the Croteau family home. It is not a place Danny would walk to alone at night without a reason. Someone gave him a reason. Someone drove him there. The city of Springfield in 1972 has a police department that is, by later assessments, overworked and underfunded. Cold cases are not a priority. When a working-class child goes missing, the urgency is real, but the resources are not always equal to the task. What the investigation will reveal, and what it will hide, will define the next 5 decades of the Croteau family's life. Danny Croteau was 14 years old, 4 feet 11 inches tall, and weighed 110 pounds. He had his whole life in front of him, and someone took it from him on the bank of a river on a Saturday night in April. The question was never what happened to Danny Croteau. The question, the one that will haunt this case for 50 years, is who the system chose to protect instead of him. Danny Croteau's body was found on April 17, 1972, 3 days after he disappeared. He was discovered in the Connecticut River near the Riverdale Street area of Springfield, less than 2 miles from where he delivered newspapers every morning. The water was cold. The current was slow. He had not drifted far. He was face down. The medical examiner's report documented the following. Danny had suffered blunt force trauma to the head. The injuries were consistent with being struck by a hard object, not a fall, not an accident. Someone had hit him multiple times with enough force to fracture bone. He had also been sexually assaulted, and then he had been placed or thrown into the river. The official cause of death was asphyxia by drowning. But the drowning was the last thing that happened to Danny Croteau. Not the first, not the worst. He was alive when he entered the water. The Springfield Police Department began its investigation immediately. Detectives canvassed the neighborhood. They interviewed members of the Croteau family. They spoke to Danny's friends, his teachers, the customers on his paper route. A picture emerged quickly. Danny had been seen on the evening of April 14th getting into a car. The car belonged to Father Richard Levine. This was not a rumor. This was not speculation. Multiple witnesses, including individuals who knew both Danny and Levine, placed the two of them together that night, in Levine's car, heading toward the river. The timeline was clear. Levine was the last person to see Danny Croteau alive. What happened on that riverbank is not documented by any witness. There are no surviving accounts of what was said, what was done, how long it lasted. What is documented is the result. A 14-year-old boy with blunt force trauma to the skull, evidence of sexual assault and river water in his lungs, and a priest who drove home alone. The Croteau family was notified on April 17th. Bunny Croteau, a woman who had built her life around her faith, her family, and the Catholic community of Springfield, received the news that her 5th child was dead. She was told it was a drowning. She was not told about the sexual assault immediately. That information came later, in fragments, through channels that were never fully explained to the family. The medical examiner's findings were documented, but what the family was told, and when, and by whom, remains one of the unresolved fractures in this case. Carl Croteau, Danny's father, would later say that from the beginning, something felt wrong about the way the investigation was being handled. Not wrong in the way grief makes everything feel wrong. Wrong in a specific institutional way. Like doors were closing before anyone had a chance to walk through them. Father Richard Levine continued to serve as a priest in the Diocese of Springfield. He continued to work with children. He continued to drive his car through the streets of Springfield. For weeks after Danny Croteau's body was pulled from the Connecticut River, Levine remained in his parish, in his community, in his life, without being formally questioned by police about the night of April 14th. Let that settle for a moment. The investigation had a suspect. The investigation had witnesses who placed that suspect with the victim hours before his death. The investigation had physical evidence of violent crime, and the primary person of interest was never brought into an interrogation room. Not in April 1972, not in May, not that year. Springfield detectives would later claim they were building a case, that they were gathering evidence before making a move, that the investigation was ongoing. What the records show is something different. What the records show is a case file that grew thinner over time instead of thicker, a list of follow-up interviews that were never conducted, a chain of evidence that was documented but never fully pursued, and one name, always the same name, sitting at the center of it all, untouched. Danny Croteau was buried at St. Michael's Cemetery in Springfield, Massachusetts. His grave marker is simple. His case file remained open, and the man who drove him to the river went back to saying Mass on Sunday morning. The Springfield Police Department assigned detectives to the Croteau case within hours of the body being recovered. By the standards of 1972, the response was not unusual. By any standard, what followed was. The initial investigation produced three things quickly. First, a cause of death. The medical examiner's findings were clear. Blunt force trauma, sexual assault, drowning. This was not an accident. This was not a suicide. This was a homicide, and it was documented as such from the beginning. Second, a timeline. Through interviews with the Croteau family, neighbors, and individuals on Danny's paper route, detectives established that Danny had left home on the evening of April 14th. He had been seen getting into a car. The car was identified. The car belonged to Father Richard Levine. Third, a primary person of interest. Levine's name appeared in the investigation within days, not weeks, days. He was not a peripheral figure. He was not someone who came up once in a single interview. He was the last known person to be with Danny Croteau before Danny Croteau turned up dead in a river. These three things, cause of death, timeline, suspect, are the foundation of any homicide investigation. Springfield had all three. And then the investigation stalled. What happened next is a matter of documented record, court filings, and investigative journalism, particularly the work done years later by reporters at the Springfield Republican and the Boston Globe's Spotlight team, whose coverage of clergy abuse in the Diocese of Springfield brought new scrutiny to the Croteau case. What the records show is this. Levine was not formally interrogated by Springfield police in the weeks following Danny's death. He was not brought into a police station. He was not placed under oath. He was not asked to account for his whereabouts on the night of April 14th in any formal, documented, legally binding way. There were conversations, informal contact, the kind of interaction that generates no transcript and leaves no trail. But a formal interrogation, the kind that matters, the kind that produces a record, never happened. Why? This is the question that has never been fully answered. What investigators said at the time, and what their supervisors said when pressed in later years, was that they were being careful, that they were building a case methodically. That moving too fast against a Catholic priest in a Catholic community in 1972 required a particular kind of institutional courage. What they did not say, but what the record implies, is that the Diocese of Springfield was not a passive bystander in this process. The diocese had resources. The diocese had lawyers. The diocese had relationships with city officials, law enforcement leadership, and the broader political infrastructure of Springfield that a working-class Catholic family with 7 children simply did not have. The Diocese of Springfield knew that Richard Levine was a person of interest in the death of Danny Croteau. What the diocese did with that knowledge, and who they called and what was said, is something that has never been fully documented. But the effect is visible in the record. The investigation slowed. The interviews stopped, and Levine remained in ministry. By the summer of 1972, the Croteau case had effectively gone cold. Not officially. The file was never closed. But the active pursuit of leads, the knocking on doors, the follow-up interviews, the building of a prosecutable case, had stopped. Danny's family noticed. Carl and Bunny Croteau began asking questions. They contacted the police department. They asked about the investigation's progress. They were told it was ongoing. They were told to be patient. They were given the language of process as a substitute for the reality of action. Danny Croteau, a devout Catholic woman who had trusted the church her entire life, began to understand, slowly, painfully, in the way that understanding comes when you do not want it to, that the institution she had trusted was not going to help her find out who killed her son. She kept asking anyway, for years. In 1985, 13 years after Danny's death, the Springfield Police Department conducted a renewed review of the case. New detectives looked at the old files. They reached the same conclusion the original investigators had reached. Levine remained the primary person of interest. He was still not formally interrogated. The review produced no charges. The file remained open. In 1991, 19 years after Danny's murder, Richard Levine was charged with crimes. Not Danny's murder, the sexual abuse of other boys, multiple victims, multiple incidents. A pattern of predatory behavior that stretched across years and parishes and the full institutional knowledge of the Diocese of Springfield. Levine pleaded guilty to sexually abusing 4 boys. He received probation, no prison time. The Diocese of Springfield paid settlements to victims, and the Danny Croteau case, the murder case, the homicide file, remained exactly where it had been in 1972, open, unresolved, with Levine's name still at the center of it. There is a difference between a case that goes cold because there are no leads and a case that goes cold because the leads were never followed. The Danny Croteau case is the second kind, and the failures are not abstract. They are specific, they are documented, and they happened at every level of the system that was supposed to protect him. The interrogation that never happened. In any homicide investigation, the last known person to see the victim alive is interviewed, formally, on the record, under conditions that produce a legal document. This is not procedure for its own sake. It is procedure because it creates accountability, because it forces the person of interest to construct a story, and stories under pressure reveal themselves. Richard Levine was never subjected to this process, not in 1972. Not in 1973. Not during the 1985 review. The Springfield Police Department has never provided a complete, documented explanation for why this did not happen. What exists in the record are informal notes, references to conversations, and the institutional memory of detectives who are now dead. What does not exist is a transcript, an interview record, a signed statement. The most basic tool of homicide investigation was never deployed against the primary suspect in Danny Croteau's murder. The diocese knew. This is not speculation. This is established fact, documented through internal church records that were later subpoenaed and made public through civil litigation. The Diocese of Springfield was aware of Richard Levine's behavior toward minors before Danny Croteau was killed. There were reports. There were concerns raised by parents. There were internal conversations at the diocesan level about Levine's conduct with boys. None of this information was shared with law enforcement. None of it was shared with the families of the boys in Levine's orbit. None of it was shared with the Croteau family. The Diocese of Springfield possessed information that was directly relevant to a murder investigation and chose, institutionally and deliberately, to withhold it. This is not a failure of communication. This is not an oversight. This is a choice. The 1991 plea deal. When Richard Levine was finally charged, not with murder, but with the sexual abuse of 4 boys, the Hampton County District Attorney's Office accepted a plea agreement that resulted in probation, no incarceration. The reasoning offered was that the victims had been through enough, that a trial would re-traumatize them, that probation with conditions was an appropriate resolution. What was not said publicly, but what investigators and advocates have argued for decades, is that a conviction on the abuse charges created a legal and evidentiary foundation that could have been used to reopen the Croteau murder investigation with new urgency. That opportunity was not seized. The plea deal was accepted. Levine walked out of the courthouse, and the Croteau family watched a man they believed killed their son receive a sentence that did not include a single night in prison. The evidence problem. By the time serious renewed attention came to the Croteau case, driven largely by the family's persistence and the broader exposure of clergy abuse in Massachusetts following the Boston Globe's 2002 Spotlight investigation, critical physical evidence from 1972 had been lost, degraded, or could not be conclusively retested with modern forensic tools. 30 years of institutional neglect had done what active concealment might not have been able to do on its own. Time had become an accomplice. DNA technology that did not exist in 1972 existed by 2002. Forensic tools that could have produced conclusive results were available. But the chain of custody on key evidence from the original investigation was, in multiple instances, broken or unverifiable. What could have been tested could not always be tested reliably. What could have closed the case could not be used to close it. The institutional response to the family. For decades, the Croteau family did everything right. They filed requests. They attended hearings. They met with investigators. They hired private attorneys. They spoke to journalists. They did not go away. They did not stop asking. And for decades, the response from the Springfield Police Department, the Hampton County District Attorney's Office, and the Diocese of Springfield followed the same pattern. Acknowledgement without action, sympathy without accountability. The language of process deployed as a wall instead of a door. Carl Croteau died without seeing justice for his son. Bunny Croteau spent the last years of her life still fighting. The system that failed Danny Croteau in 1972 continued to fail his family for every year that followed. There is a word for what happened in Springfield. The word is not incompetence, though incompetence was present. The word is not corruption, though the proximity of power and protection suggests something close to it. The word is impunity, the condition in which certain people in certain institutions with certain connections operate with the understanding that the rules which apply to everyone else do not fully apply to them. Richard Levine operated inside that condition for decades, and the system, the police department, the district attorney's office, the diocese, maintained it, not always through action, sometimes simply through inaction, which in the end produces the same result. In 2002, the Boston Globe published its Spotlight investigation. You know what that investigation did to the Catholic Church in America. What you may not know is what it did specifically to Springfield, Massachusetts, and to a case file that had been sitting in a drawer for 30 years. The Spotlight team's work was national in scope but local in impact. Diocese by diocese, the investigation forced the release of internal church records that had never been intended for public view. Personnel files, transfer documents, internal memos, the paper trail of an institution managing its own crisis in private while the damage accumulated in public. The Diocese of Springfield was not exempt. Under legal pressure, civil suits filed by abuse survivors, subpoenas issued by state investigators, the weight of a national reckoning that made further concealment politically and legally untenable, the diocese began releasing documents. And inside those documents was something that changed the Danny Croteau case permanently. The records showed that the Diocese of Springfield had received formal complaints about Richard Levine's behavior with boys as early as 1968. 1968. 4 years before Danny Croteau was killed. These were not vague concerns. These were specific reports from parents who had witnessed or been told about Levine's conduct. Physical contact with minors that crossed every boundary of appropriate pastoral relationship. The diocese documented these complaints. The diocese investigated them internally. And then the diocese transferred Levine to a different parish. They did not contact law enforcement. They did not warn the families in the new parish. They moved him. And in the new parish, at St. Catherine of Siena, Richard Levine met the Croteau family. This is the moment the case changes, because what this document establishes is not just institutional negligence, it establishes a timeline. The Diocese of Springfield knew Richard Levine was dangerous to children in 1968. Danny Croteau was killed in 1972. For 4 years, the diocese possessed information that, had it been shared with law enforcement, with parents, with anyone outside the institutional walls, might have prevented what happened on the bank of the Connecticut River on the night of April 14th. 4 years. But the documents revealed something else. Something that moved the case from institutional negligence into territory that investigators and prosecutors would spend years trying to act on. Among the diocese's internal records was documentation showing that after Danny Croteau's murder, after the Springfield police had identified Levine as the primary person of interest, diocese officials had been in contact with individuals connected to the investigation. The nature of those contacts was not fully specified in the documents, but the timing was impossible to ignore. The conversations happened during the period when the investigation was active. The investigation slowed immediately after. Levine remained in ministry. In 2004, the Hampton County District Attorney's Office announced that it was formally reopening the Danny Croteau murder investigation. For the first time in the case's history, a grand jury was convened. Witnesses were subpoenaed. Records were examined. The full weight of prosecutorial authority, the authority that had been conspicuously absent for 32 years, was brought to bear on a case that had never been properly investigated. Richard Levine was called to testify. He invoked his Fifth Amendment right against self-incrimination. The man who had never been formally questioned in 32 years of investigation finally sat across from investigators and said nothing. The grand jury investigation lasted nearly 2 years. It examined the original investigation. It examined the diocese's records. It examined the timeline of Levine's ministry, his access to Danny Croteau, and the specific events of April 14, 1972. In 2006, the grand jury concluded without returning an indictment, not because Levine was found innocent, not because the evidence pointed elsewhere. The grand jury concluded without an indictment because the evidence, degraded, incomplete, its chain of custody fractured by 3 decades of institutional neglect, was not sufficient to meet the legal standard required for prosecution. The case was not closed. It was returned to its permanent condition, open, unresolved, waiting. But something had changed. The grand jury process had forced the public documentation of facts that the diocese and the Springfield Police Department had kept out of public view for 30 years. The record now showed, officially, legally, irreversibly, that Richard Levine had been the primary suspect in Danny Croteau's murder from the beginning, that he had never been formally interrogated, that the diocese had known about his conduct with minors years before Danny died, that internal church communications had occurred during the period when the investigation was active. None of this produced an indictment. All of it produced a record, and a record, unlike a conviction, cannot be expunged. Richard Levine died on September 9, 2021. He was 79 years old. He died without ever being charged with Danny Croteau's murder. He died without ever formally answering, on the record, under oath, in a court of law, the question of what happened on the bank of the Connecticut River on the night of April 14, 1972. He died as he had lived for 49 years after Danny's death, protected, untouched, free. The Croteau family learned of his death through the news. There was no call from the district attorney's office. There was no statement from the diocese. There was no acknowledgement from the Springfield Police Department. The man they believed killed their son died in his bed. And the phone did not ring. There is a photograph of Bunny Croteau that was taken sometime in the 1990s. She is sitting at a kitchen table. In front of her there are papers, Documents, letters, copies of police reports. Her hands are flat on the table. She is not looking at the camera. She is looking at something just outside the frame. She looks like a woman who has been waiting for a very long time, and who has learned that waiting does not mean the answer is coming. The Croteau family did not collapse after Danny's death. They could not afford to. There were 6 other children. There was a household to maintain. There was a life that had to keep moving even when the center of it had been destroyed. But the damage was not invisible. It was simply carried quietly. The way working-class Catholic families in 1972 carried things. Internally, without public display, with a faith that was being tested in ways no parish sermon had ever prepared them for. Carl Croteau struggled with what had happened to his son in ways he rarely articulated publicly. He was a father who had failed to protect his child, not through any fault of his own, but in the way that fathers absorb that weight regardless of fault. He pushed for answers. He made calls. He showed up at police stations and district attorney offices and demanded to be heard. He was heard. Nothing happened. Carl Croteau died in 1995, 23 years after Danny, without justice, without answers, without the phone call that would have told him that the system had finally done what it was supposed to do. Bunny Croteau outlived her husband by many years. She became, in the absence of institutional action, the engine of the family's pursuit of justice. She was not a public figure. She was not a campaigner by nature. She was a mother, and the particular tenacity of a mother who knows what happened to her child and refuses to accept that the world is allowed to simply move on is something that institutional systems consistently underestimate. She worked with attorneys. She spoke to journalists. She provided testimony and documents and her own memory, sharp and detailed even as she aged, to anyone who was genuinely trying to understand what had happened to Danny. She was present when the grand jury was convened in 2004. She was present when it concluded without an indictment in 2006. She sat in those rooms and watched the system process her son's death one more time and produce one more document that changed nothing. She did not stop. Danny's siblings carried the case with them into their adult lives. His brother Joseph Croteau became one of the most vocal members of the family in pursuing accountability. From law enforcement, from the diocese, from the political structures of Springfield and Hampton County that had spent decades looking the other way. Joseph was a child when Danny died. He grew up in a house where his brother's murder was an open wound, never fully acknowledged, never fully healed, never given the institutional recognition that would have allowed the family to grieve in the way that grief is supposed to work. He would say in interviews decades later that what the system did to his family was not just a failure to solve a murder. It was a second crime, committed slowly, bureaucratically, without violence but with the same effect, the erasure of a person. There are other families in this story. The boys that Richard Levine abused before Danny Croteau, the ones whose parents brought complaints to the diocese in 1968, whose concerns were documented and buried. Those families carry their own damage. The boys who were abused after Danny's death, in the years when Levine remained in ministry, protected by an institution that knew what he was. Those families carry theirs. The Diocese of Springfield's decision to move Levine rather than remove him created a chain of harm that extends far beyond the bank of the Connecticut River on one night in April 1972. Each link in that chain is a child. Each child is a family. Each family is a story that this system never fully acknowledged. Springfield itself bears a mark from this case. Not the visible kind, not a memorial, not a public reckoning, not the kind of institutional acknowledgement that cities sometimes make when they have been forced to confront their own failures. The mark is the quieter kind. It is the knowledge, carried by people who were alive in 1972 and who are still alive today, of what happened and what didn't happen and why. It is the distrust of institutions that grows in communities where institutions have demonstrated, over decades, that they protect themselves before they protect the people they are supposed to serve. It is the specific damage that impunity does to a place, not all at once, but slowly. In the way that a structural failure weakens a building before it collapses, Springfield did not collapse, but it carries the weight. Danny Croteau would have been 67 years old in 2025. He might have had children, grandchildren, a career, a life built in the city where he delivered newspapers as a boy. He might have been someone's father, someone's grandfather. He was 14 years old and 4 feet 11 inches tall, and he had a baseball cap tilted slightly to the left, and someone took everything that came after. Let's be precise about what happened in Springfield. Not emotional, not rhetorical, precise. A 14-year-old boy was murdered in April 1972. The primary suspect was identified within days. That suspect was never formally interrogated. The institution that employed him possessed prior knowledge of his predatory behavior and withheld it from law enforcement. The physical evidence degraded over 30 years of institutional neglect. A grand jury convened 32 years after the murder concluded without an indictment. The suspect died in 2021 without ever being charged. That is the case. That is what happened. And if you read those sentences and feel something harden in your chest, that reaction is correct. That reaction is the appropriate response to a system that functioned exactly as it was designed to function, just not in the direction of justice. What failed, and why it matters beyond Springfield. The Danny Croteau case is not an anomaly. It is a template, not in the sense that every cold case follows this pattern, but in the sense that the specific combination of failures present in Springfield in 1972 is not unique to Springfield or to 1972. It is a pattern that appears wherever 3 conditions exist simultaneously. First, an institution with significant social and political capital. Second, a suspect who operates inside that institution and is protected by its resources. Third, a victim who comes from a community with less institutional power than the organization protecting the perpetrator. When these 3 conditions exist together, the investigation does not fail by accident. It fails by gravity. The system bends toward the center of power. Not because every individual in the system is corrupt, not because there is a meeting in a room where someone says the words, but because institutions protect themselves through 1,000 small decisions, a phone call not made, an interview not scheduled, a file reviewed and returned to the drawer, that individually look like procedure and collectively look like cover. The Diocese of Springfield learned to say the right words. In the years following the Spotlight investigation, the diocese acknowledged a pattern of clergy abuse that stretched across decades. Settlements were paid, apologies were issued, structural reforms were promised. Richard Levine's name appeared in those acknowledgments. His connection to Danny Croteau's murder did not. The diocese has never, in any public statement, in any legal proceeding, in any communication with the Croteau family, formally acknowledged that its decision to transfer Levine, rather than remove him in 1968, placed a known predator in proximity to the child who was subsequently murdered. That acknowledgement would not bring Danny back, but its absence says something precise about the limits of institutional accountability, about the difference between an organization that has learned to say the right words and an organization that has genuinely reckoned with what it did. The district attorney's office did not convene a grand jury until 2004, 32 years after the murder. By that point, key witnesses were dead. Physical evidence had degraded. The legal standard for prosecution was effectively unreachable. Each year between 1972 and 2004 represented a window. Each window closed. And by 2004, what remained was a proceeding that could document the failure without correcting it. In any investigation, absence of documentation is itself documentation. The absence of a formal interrogation transcript for Richard Levine, across 32 years and multiple reviews of the Croteau case, is not a gap in the record. It is the record. It tells you exactly what decisions were made and exactly what was prioritized. It tells you that the working-class Catholic family on Dynamite Street did not have access to the kind of institutional protection that ensured their son's primary suspect was never formally questioned. It tells you that in Springfield, Massachusetts, in 1972, a priest collar was more effective protection than innocence. If you've made it this far, you already know this channel is different. Dead Ends exists for cases like this one. Cases where the system didn't just fail, but where the failure was structural, documented, and never fully accounted for. Subscribe to Dead Ends. Stay with us for every case that was never truly closed. Because the work of a channel like this is not entertainment. It is the maintenance of a record. The Danny Croteau case did not end in a courtroom. It did not end with a conviction. It did not end with an apology from the institutions that failed him. But it is documented. The grand jury proceedings are public record. The diocese's internal documents, released under legal compulsion, are public record. The timeline of investigative failures is reconstructible from court filings, journalistic investigations, and the testimony of the Croteau family. The record exists, and as long as the record exists, the case is not entirely cold. It is waiting for a prosecutor willing to look at it again, for a witness who has not yet spoken, for a document that has not yet surfaced, for the specific combination of institutional will and evidentiary sufficiency that has not yet aligned. Cold cases close, not always, not quickly, not without cost, but they close. As of the time of this recording, the murder of Daniel Joseph Croteau remains an open homicide investigation in Springfield, Massachusetts. It has been open for more than 50 years. Richard Levine died on September 9, 2021, at a care facility in Ludlow, Massachusetts. He was 79 years old. His death did not close the case. Under Massachusetts law, a homicide investigation does not automatically close upon the death of the primary suspect. The file remains active. The Hampton County District Attorney's Office has not formally archived it. What Levine's death did close was the possibility of prosecution. A dead man cannot be indicted, cannot stand trial, cannot be convicted. Whatever happened on the bank of the Connecticut River on the night of April 14, 1972, died with him. Not as legal resolution, but as permanent inaccessibility. The answer, if Levine carried it, is gone. The Diocese of Springfield has undergone significant structural changes since the 2002 Spotlight investigation. Bishop Thomas Dupree, who led the diocese during the period of renewed scrutiny and who was himself later charged with sexually abusing minors, resigned in 2004. The diocese has paid tens of millions of dollars in settlements to abused survivors across multiple decades of litigation. Internal review boards were established. Reporting protocols were reformed. None of these reforms addressed the Danny Croteau case specifically. None of them produced an acknowledgement that the diocese's actions in 1968 were directly connected to Danny's death. The reforms happened around the case. The case itself remained untouched. The Springfield Police Department has not announced any active investigative developments in the Croteau case since the conclusion of the grand jury process in 2006. There is no publicly known task force, no announced review, no indication that new evidence has surfaced or that new witnesses have come forward. The file is open. The investigation is, by every public indication, dormant. The Croteau family has continued to seek acknowledgement and accountability through whatever channels remain available. Joseph Croteau has spoken publicly about the case in multiple interviews over the years, to local journalists, to documentary filmmakers, to anyone willing to keep the record visible. Bunny Croteau, Danny's mother, passed away in her later years, having never received the formal acknowledgement she sought from the diocese, the police department, or the district attorney's office. She died as she had lived in the decades after Danny's murder, still asking, still waiting, still right. There are details of this case that remain sealed or inaccessible. Grand jury proceedings in Massachusetts are confidential by statute. The full record of what was presented to the grand jury in 2004 and 2005 is not available to the public. This means that the complete picture of what investigators know and what they were unable to prove exists in documents that cannot be examined. It means that the gap between what happened and what can be legally established may be smaller than the public record suggests, or larger. It means that the case is not fully knowable from the outside, and that unknowability is itself a form of injustice. In the broader context of the Catholic Church abuse crisis, the Danny Croteau case occupies a specific and significant position. It is one of the few cases in the United States where the connection between institutional concealment of clergy abuse and the subsequent murder of a child is documented, not alleged, not speculated, but documented through court records, released diocesan files, and grand jury proceedings. The case is not forgotten. It is simply unresolved, which is its own kind of statement. A case this documented, a suspect this clearly identified, a failure this thoroughly recorded, and still, no conviction, no formal institutional accountability, no closure for a family that has been asking the same question for more than half a century. What does it mean when a system documents its own failure this thoroughly and still cannot correct it? That question does not have a clean answer. It has a case file, open, in Springfield, Massachusetts, where it has been since April 1972. On the morning of April 17, 1972, a man walking along the Connecticut River found a boy face down in the water. He called the police. The police came. They documented what they found. And then, for reasons that are now part of the public record, reasons that involve a priest and a diocese and a system that chose protection over truth, almost nothing happened. Danny Croteau's case file is stored somewhere in the administrative infrastructure of Springfield, Massachusetts. It is not a cold case in the technical sense. It was never formally closed. It is something harder to name. It is a case that was never fully opened, never fully pursued, never given the institutional urgency that a 14-year-old boy beaten, assaulted, and drowned in a river deserved from the first hour. Richard Levine is dead. The Diocese of Springfield has reformed, structurally, procedurally, on paper. The Springfield Police Department has moved through generations of leadership since 1972. The Hampton County District Attorney's Office has changed hands multiple times. And Danny Croteau is still 14 years old in every photograph that exists of him, still wearing that baseball cap, still standing in front of the river that would take his life 3 days after the shutter closed. There is a version of this story where the system worked, where a detective in 1972 walked into a rectory and sat across from Richard Levine and asked him, formally on the record, under the weight of legal consequence, what happened on the night of April 14th. Where the Diocese of Springfield, faced with that interrogation, made the decision to cooperate rather than protect, where the chain of evidence remained intact, where a jury heard the case, where the Croteau family received the phone call. That version of this story did not happen. What happened instead is what you have heard over the last hour, a family that did everything right and received nothing in return, a suspect who died free, an institution that learned to apologize without learning to account, a system that documented its own failure so thoroughly that the documentation itself became the only form of justice available. The Connecticut River still moves through Springfield, slow, brown, indifferent to what happened on its banks 50 years ago. The river does not remember Danny Croteau, but the record does, and as long as the record exists, as long as people read it, report it, refuse to let it be buried under the next news cycle and the one after that, the case is not entirely closed. It is waiting, the way justice waits when the system fails it, patiently, permanently, without guarantee. If this case matters to you, if Danny Croteau's name is one you will carry with you after this video ends, subscribe to Dead Ends. Share this episode with someone who needs to understand what institutional failure looks like from the inside. And if you know something, anything, about what happened on the night of April 14, 1972 in Springfield, Massachusetts, The Hampton County District Attorney's Office still has an open file. Danny Croteau, born 1957, died April 14, 1972, Springfield, Massachusetts. Case open.